I'm sitting here with Hal Rosenberg, as you heard, and we're going to talk about effective opening statements. And my first question for you is, we've all seen research that a large percentage of cases, something on the order of 60 or 70% I've seen, are won on the opening. So what are the critical elements of an effective opening?
Well, I think, thanks. I think that you've actually witnessed many of the things that make an effective opening. The very first thing that you really want to do is you want to start your opening statement with getting the jury to identify with your client, whether it's an injured plaintiff or whether it's an injured corporation. And generally, the way you do that is you start with the injury. You start talking, you try to get the jury to put themselves in the shoes of your client, and you start by knocking them right off by saying, if it's a death case, if it's a case of serious injury, that on such and such a date, this person, this age, was killed, died, blah, blah, blah. The second thing that you want to have in an opening, of course, is a narrative of what you intend to prove. We get two speeches in the course of a trial. The first speech is unfettered by anything that has occurred in the courtroom. The second speech, it has to take into account everything that has occurred in the courtroom. So in the opening statement, the narrative that you give is really your only opportunity to get an unfiltered, unfettered version of the case before the jury. The third thing you want to talk about is the burden of proof, and I think both sides have done that very effectively. When you're the plaintiff, of course, you want to emphasize how light the burden of proof is and contrast that with what happens in criminal cases. You want to emphasize to the jury that it's not our job to prove guilt beyond a reasonable doubt. You want to talk about how very light it is, and then, of course, how you embrace it and how the evidence in the case is going to demonstrate that you've far exceeded the legal burden of proof. From the defense side, and you heard that done very effectively here today, from the defense side, you just want to emphasize that they have to prove it. They have to prove it, they have to prove it. And I think the final part of an opening statement is tell the jury what you want. You have to tell the jury what you're looking for. If you're a plaintiff and you're looking for money damages, don't be afraid to do that. From the defense standpoint, they like to make it sound as if what you're doing is coming in with a gun and demanding all their money, that they are a victim of a crime. From the plaintiff's side of things, you have to be very clear, you have to clearly communicate to the jury that this is the only way in our system of justice that justice is done, and don't be ashamed or afraid to tell the jury that you're looking for a large, substantial money award.
And how do you deal with weaknesses in your case in the opening? We heard that commented on by our judging panel, but that was a question I was curious about. How hard do you hit them? Do you highlight the weaknesses in your case? Because every case has them. Yes. The answer to that, of course you do, because the jury has to, number one, has to trust you, has to trust the lawyer, and has to believe that what you are telling them is the truth, and has to believe that the version of the facts that you want them to accept and the conclusion that you want them to reach is the right one. So yeah, you definitely mention the weaknesses in your case, but you explain them. You explain them. Is there any timing element to that? Do you like to do it up front? Does it just depend on the case, or is it? Well, I wouldn't think would want to close with that.
Well, you definitely don't close with it. I would weave it into the narrative, into the second part of the opening statement. The first part of the opening statement, you got to hit them, suck them right in. This is what happened to this person, and this is a horrible thing. Generally, you've got them at that point. And then when you're explaining to the jury how you're going to meet your burden of proof, you can absolutely bring in the weaknesses.
And any difference in your mind? I know you're a plaintiff's attorney, but any difference in the approach between the defense and the plaintiff side for that kind of thing?
Well, yeah, there's going to be a little difference in approach because if the plaintiff has done his job, the jury is going to have heard about all the weaknesses in the defendant's case before the defendant even gets up to talk. So the defendant's going to have to start off by explaining. It doesn't have to start the speech by explaining. I think the defense should start the speech also by getting the jury to identify with the client. But yes, very much of the defense opening is going to be trying to neutralize some of the things that the plaintiff has said.
And how do you avoid argument in the in the opening? I mean, and how, in your experience, how rigid or how much do judges like Judge Medina let you get away with that?
Well, here's how you avoid argument in the opening. Before you make an argument, which of course is inappropriate, you preface it by saying the evidence will show. As long as you say the evidence will show, you can get away with just about anything.
Judge, you agree with that?
Mic's not on. Yep, very good comments. And I just want to say these lawyers up here, I think they did a great job. My career, I was the Associate General Counsel for a Fortune 100 company, took me all over the world and had cases in every jurisdiction, including the United States Supreme Court. And these lawyers are as good as any I've ever seen. They waved the flag to the jury, which I think you have to do. They were personalized with the audience. They had no problem making it personal with the witness that was going to testify against the company. I thought they were great. And your comments are all on point.
And you said demonstratives during the opening. Ever? Sometimes? When?
Yeah, the answer is yes. And the way you go about that is, of course, you hire Magna, and Magna puts all the demonstratives together for you. I don't like to, and this, of course, is a matter of personal preference. I don't like to rely too heavily on demonstratives. First of all, as His Honor will tell you, you get into big pre-opening fights with the other side in what is a permissible use of demonstrative evidence. And so you really don't want to get dragged down into the weeds on evidentiary fights, number one. Number two, as I say, it's personal. Some people like to stand up with PowerPoints and spend their entire time with visuals, just repeating what they are, or highlighting what they are saying to the jury. I've seen it both ways. Sometimes it's effective, and sometimes it is ineffective and counterproductive because what the attorney must do in the opening statement, and he can't do it any time else, is he has to develop a connection to the jury. And if you are relying on gimmicks and bells and whistles, too many of them, you can wind up losing that connection or losing that opportunity to connect to the jury. But it's a matter of personal preference and personal taste.
Judge, anything to add?
I absolutely agree. It's a fine balance. Participated in a trial most recently in Bexar County. We spent 30 minutes arguing over a PowerPoint presentation that was going to take 2 minutes, but we worked it out. I think PowerPoint presentations are good in voir dire, certainly when you're trying to explain the burden of proof to the jury, and whatever that may be in your jurisdiction. But yeah, they're good. And don't get lost in a PowerPoint presentation because the jury wants to hear from you.
And you mentioned connecting with the jury, which is obviously the name of the game, but how do you do that, but B, during the course of your opening, or your closing for that matter, but in this case opening, you're going to see certain reactions from certain jurors. So how do you develop that connection, and do you adapt on the fly in your opening to try to react to the jury, or do you just go with what brought you there?
Well, first of all, you have to be very, very careful to thinking you're reading the jury's mind, especially in an opening statement. The way you connect to the jury is you don't use notes, you don't have any artificial barrier between you and the jury, and you look everybody in the eye. You don't stare at anybody, but you make sure you look people in the eye when you speak to them. That's the way you establish a rapport and a connection to the jury. I had one experience one time where I saw that I'll tell you about two experiences. One, a positive one, and one a negative one. Both times I read the jury absolutely correctly. These were both during closing arguments. In one case, one of the jurors, a juror that I really, really struggled with. I wasn't sure whether I should take her or not take her. She had lots of things going against her, but I didn't want to waste a peremptory challenge on her. And as I was arguing what I thought was the strongest point of my case, she went like this. That indicated to me that she was against me. And as it turned out, not only was she against me, but she was such a powerful personality that she became the foreperson of the jury and brought back a bad result. The opposite happened in another case where I had 2 or 3 jurors that by the end of the case were virtually jumping out of their seats, smiling, laughing, almost wanting to talk to you. You know you're going to do okay under those circumstances. But during an opening statement, I wouldn't read anything into the. It's not a question of sticking to your game plan. You have to be flexible in a courtroom. And if an idea or a thought comes to you based upon the people that you're looking at and the way they're looking back at you, you go with that. But I wouldn't be a mind reader. I wouldn't change my plans because I think that one jury likes me or likes what I'm saying.
Okay, as we wrap up here, I'm going to ask the same question to the judge, but first of all, could we have the plaintiff, Christine, be seated in the witness chair? And I'm going to introduce the next panel in a minute. But is there maybe a couple of absolute rules thou must never do in an opening? And I'm going to ask you, Judge Medina, after he's done.
I only have one absolute rule never to do in an opening, and that is to overpromise. I make very certain that what I am telling the jury they are going to hear, they are definitely going to hear.
Judge?
I think that's well said. I want to touch briefly on the other point about observing the jury. You have your co-counsel there, and hopefully if you have a representative from either side there observing the jury, body language really works. And if you watch the body language throughout the trial, you'll know whether or not you should increase your settlement offer, take it off the table. But I think you can be guided by that somewhat, but always stick to your game plan. And overpromising, that's such a significant part of what we do. Tell the jury what you intend to do, say what you say, mean what you mean, and do it. It's that simple. And deliver. And if you have bad facts, get them out, and that way the jury didn't think you're hiding the ball somewhere.
Great. Howell, thank you very much. I think it's been really informative. How about a hand for Howell?